So say dear Owura Chachuchi Kata say lawyer ni ogina mama mpani dada Akufo-Addo e ba court ne e be kan say enkrata bi wo ho a eye yisi na say electoral commission emfa ma omo no omo che sansa no mo ka no enya ade a etwa ne kwan mu na ensem na kire mu che ade a enkrata dodo na e wo NDC fo no ana so mampani dada mpanifo egina lawyer fo egina mu e de ama no ensem dodo na wo mo ho nti omo ntia ase se omo san ebisa enkrata Owura Akoto ampa ono so lawyer ni ogina mampani no ono so kasa se basa na NDC for na so mampani dada lawyer for gina ode mano no omo twa asem no e de akwa kugina baabi esanse se wo ba court na se wo de asem na e ba de a na wo nkrata wo nsem ni nyina nya afi na obedu court na we bisa se yemfa nkrata foforo ema sanso na Owura Kodwo Oponkroma a ono so ka mampani Akufo-Addo lawyer for no so e kan se de NDC for no ye no e kire se ensem no ompese omutwe ejira nchen a de omo kan de enya ade a ejina ne kwan mu.
This application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation, but it is not a matter that you have as of right. It is at the discretion of the court, and you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity. You heard Mr. Chachuchi Kata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there is anything wrong with the copies that he has, and therefore asking to inspect the originals because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. We also noticed principally that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondents or the defendants to respond. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent, and they have not demonstrated any necessity for it.
Abrana na adodan